So another way of defining rainy Tuesday morning in the Avera case. So once again, we can have one standard apply to all the people that are protected even under U.S. principles of law, which are the non-settlor beneficiaries, right? All 50 states in the bankruptcy code recognize the concept of the spendthrift trust. So when I create an integrated estate planning trust as the settlor and I name my spouse and my children as the beneficiaries, their creditors, under principles of spendthrift trust law, will not be able to get at the assets, even if, in my home state, Colorado law is applied. And we're not one of the states, really, that has specific asset protection trust domestic-style legislation. And then as to me, as that special category of beneficiary called the settlor beneficiary, I would put in language that cuts back my right. I mean, I go to work every day. I still make a living. I hope to be 90 years old and still going to the office and getting in the way. And still taking a paycheck, by the way. But the point is, the trust that I have set up in my own situation and that you will set up for many of your clients truly are family trusts for the benefit of the family as a whole. And I'm probably the last one ever to receive a penny from that, and that's okay with me. That's the intended design. And if you speak to your clients in those sorts of terms and then build in this sort of DeMaria and Avera cutback language as to their beneficial interest, even under principles of U.S. law, if the court says, Cook Islands, are you kidding? Belize, what are you talking about? Nevis, you got to be joking. You know, this is Florida. This is New York. We do things our way here. If that's what the court says, you can say, well, under the way we do things here, your response is, this is still protective and here's why. So I think that's an important design variable. Let me see what else I wanted to mention, because I'm probably out of time or down to time.
Well, take a minute.
Okay. Let me see.
Because Carl's going to come up and scare everybody.
Let me close with just a couple of comments on key clauses. I think the other materials, outline materials I've covered in the course of my time with you, but let's jump to the end at 7.21. Key trust clauses. Obviously in our, whether it's domestic or foreign integrated estate planning trust, we want to have a spendthrift clause. That is so obvious, but believe it or not, I have seen trusts that do not have spendthrift provisions, even as to children, even as to a spouse, even as to the third-party non-settlor beneficiaries. In other words, somebody drafted a trust and didn't put it in. I think that means, unless you have that sort of a clause, the door to the trust assets remains open even with respect to the non-settlor beneficiaries and their creditors. So I know it's painfully obvious, but I've seen it. So make sure there's a spendthrift clause in the trust. The duress clause is a key clause. The duress clause is the clause that says if somebody has a power and they're forced to exercise that power as a result of duress, an involuntary action, that sort of thing, then it's an ineffective exercise of that power by them. So even if the settlor is the protector and they have a certain veto power that they're compelled to exercise to the foreign trustee, if that's under duress, it's an ineffective exercise of that veto power and the foreign trustee won't follow it, leading to the result that we want, which is hopefully the funds stay where they are, which is offshore. Key clause under 10C, choice of governing law clause. If we're going to have a Cook Islands trust, we want to specify that. If it's going to be a Nevada trust, we want to specify that. What if we want to have a Nevada trust today that has the ability to morph into a Cook Islands trust tomorrow? Change of domicile provision. Change of governing law clause under 10D. Simply a provision that says the trustees can change the applicable law governing the provisions, the interpretation, the administration, the validity of the trust Another key clause I would say is make sure there's the ability to have the trustee create further trusts or to settle further trusts or create companies or limited partnerships or LLCs anywhere in the world, so that if need be, the trustee feels it's necessary for the protection of the assets. As a protective measure, the trustee can certainly spread things out. And it's not the individual doing it. The individual parted with the assets years ago.
I suppose, Barry, would be very important to have a clause that says that the trustee has authority to pay legal fees.
Directed to.
Directed to pay legal fees in the event there's litigation and design counsel is caught up, and the trust should have authority to pay the legal fees for the defense.
That's clause 1.1. Finally, I'll just mention, in terms of design variables, obviously, whether we have a partnership, that's a design variable. Whether we have the client is the general partner or somebody else, that's another design variable. And again, I'm starting with that very tight structure of offshore, no U.S. connections, all the money's overseas, only U.S. beneficiaries with limited rights, and then backing up from that. Every step of that backup involves a design variable that leads to something that's more flexible, but the more flexible it is, the more exposed the assets may be. In conclusion, I'm done. Thank you very much.